Good afternoon, everybody. This is Law 2020. How you doing today? Brought to you by your friends in the offices of the BCN Law Firm right here in Central Florida. You can join the conversation right now by giving us a call at 855-297-9696. That's 855-297-9696. Or you could actually text us on your smart device at 21232, 21232. And a lot of people still just kind of mysteriously don't understand that. And what it is you go on your texting feature, and where you might put in somebody's name or you'd put in their address or, whatever. All you have to do is put in 21232, just like a phone number, and it will come right onto our computer screens right here in the studio. It's called MoGreet. It's an industrial thing. We have attorney Brian Monk with us today from the BCN Law Firm, the BCN Law Firm. And I think most importantly, we're live. We are on Memorial Day weekend. We're live. And having said that, we certainly do want to thank all of those families who have seen sacrifice of their loved ones and their relatives who fought for us. And we also want to recognize all of those families right now that are listening who have loved ones overseas. And we understand the president is just arriving in Afghanistan to greet some of them. But anyway, if you have somebody serving, whether at home or overseas, we want to give them our best today and our salute. And tomorrow, as you're doing the hot dogs and the libations and all that, take a little time to explain to the kids in your family what it's all about. Brian Monk is here. Brian, tell everybody about the two types of law that you specialize in. And I guess at first blush, they seem pretty far apart, but sometimes they might even connect. I hope they don't.
Yes, sir. Absolutely. Good afternoon. And yes, happy Memorial Day weekend. And the law firm also extends gratitude to all those who have served our country. We are live here today, and I practice primarily in the areas of marital and family law, as well as criminal defense. And sometimes we have cases where those issues overlap, sometimes not. Because I handle those two areas, often I do get cases with some overlapping issues, domestic violence, injunctions, restraining orders, things like that.
One of the things that you and I talked about before, and it comes up on many of our shows, is a marriage, stems from an emotional tie between two people, and they just want to spend their lives together. And over the years, things happen. And all of a sudden, especially during all of these years of short sales, modifications, foreclosures, economic cutbacks, people realize that it is also a business. And oftentimes, people aren't partners when it comes to the bottom line in the checkbook. And that's where the fights begin. And oftentimes they end up in your office or in the courts. So we've got an awful lot to talk about today. You can call in with your criminal questions. You can call in with your, even with your family law questions. Maybe you're going through a divorce. Maybe you're thinking about a divorce. Or maybe you're pretty far along in the process and there's things happening that you don't understand. And your legal counsel is not communicating with you. And having said that, I will remind you, you do not have to use your real name. We realize this is very sensitive, whether it's a family law matter or a criminal matter. So please feel free to not use your name. You can use the name today, Josh or Tim. Okay? And use one of those two names. We got no problem there. Just don't use Brian or Rob. We just don't want that done. All right. We have family law questions to share with Brian. We also have some criminal law questions to ask. And let's start off by getting the ball rolling with a family law question. Here's something I've never heard of before. What is the right of first refusal when it comes to child care following a divorce? What does that mean?
Well, the right of first refusal, a lot of people have heard of this phrase. A lot of people haven't heard of this phrase. But when people have finalized their divorce, whether they do it on their own or whether they have attorneys involved, often a provision of the parenting plan is what's entitled child care. And what child care means is what happens with the child when the parent who's supposed to be watching the child is unable to do so. They have to step out, whether it be for 20 minutes to run down to the store, or they have an unexpected call at work that's going to pull them away from personally watching the children for 2, 3, 4 hours. The right of first refusal generally says that the other parent should be given the first opportunity to care for those children before the parent who's supposed to be watching them goes ahead and picks up the phone and calls a babysitter or some third-party caregiver. Oftentimes, there's a designated window of time for the right of first refusal. So if we say, hey, we're going to have a 2 or 3 hour right of first refusal, that means that if you don't require childcare for over 2 or 3 hours, then you wouldn't have to pick up the phone and call the other parent. But if you know you're going to be away for that period of time or longer, you should pick up the phone and give the other parent the opportunity to watch the children. Oftentimes there's exceptions like a new spouse or grandparents. So we could say, hey, there's a 2 hour right of first refusal, but grandparents will be an exception. I don't have to call you if grandparents can watch the children. Mm-hmm. This is one of those issues. I would say one of the pitfalls of when people sometimes do their own divorces is this is one of those issues that people don't necessarily think about on the front end. And then on the back end, it can become a real problem. Dad might say, hey, I can watch the kids this amount of time. They come to a time-sharing agreement based on his representations. And then, he has a new work schedule or something changes, or maybe he just doesn't want to exercise the time. Mm-hmm. And he's leaving them with his girlfriend or with someone the kids don't even know. Someone will come to my office and say, this isn't what I anticipated. This is awful. They should be with me, the mother, instead of the girlfriend. And you end up litigating that if it's not sufficiently spelled out at the outset.
I can imagine that really raises some ugly issues, okay? The husband and wife get a divorce. They got the child sharing agreement, and all of a sudden, dad takes up with the new little chickie, or mom takes up with the live-in boyfriend, and she says, well, I was only going to publishing to get my hair done, so I just left the kids with John. Well, maybe dad doesn't like John and think he's a good example.
And it all depends. It's one of those things, it's a case-by-case basis. I think the courts expect people to move on, have new significant others, and zipping out to the store for 10 minutes. No, it probably would be more of an interruption to call dad. But it's when it's long periods of time, or if there's a bona fide actual problem with this third-party caregiver.
And there again, that's what you guys bring to the air. You invest in this time of your own money to bring this kind of news to the people. But again, when people try to do things themselves, they think, oh, we're just going to get a divorce. It can't be that big a deal. We're just going to sit down and go through it. But you guys bring up little instances like this. All right, who's going to take care of the kids on a weekend where mom has said, well, dad gets every other weekend with the kids, and I planned on being at a convention that weekend. And what happens when dad says, oh, I've got to work overtime that weekend. I can't do it.
And people who get along generally can work those things out. But unfortunately, these are people that are divorcing because they can't get along. So oftentimes these things become big problems. When you're filling out the family law forms that the Supreme Court has promulgated for pro se or do-it-yourself divorces, there's nothing there's no flashing lights or big arrows indicating, hey, this is going to be a hot button issue for your family. It just looks like a simple form. Check this box, check that box. And then all of a sudden, after the final judgment's entered, they realize they've got a problem.
Yeah. Well, the other thing I can think of is even if they're really getting along, isn't it better to have everything planned out? I mean, isn't it just smarter to have all the things that they hadn't thought of, let Brian think of and say, even though you guys are buddies, this is going to be a bone of contention, and we better just eliminate another bone of contention.
Absolutely. Beneficial to have somebody with experience review your documents, guide you through the process. Absolutely.
Okay, very good. So if you want to text us, 21232, what you'll want to do is go ahead and text us at 21232, and you'll have about 160 individual characters, or about 5 lines. All right, that's about 5 lines. And you can just add another text and another text and another text, and we'll recognize the phone number. But it's better to do it 2 ways so Brian can ask you questions. That's why we ask your call at 855-297-9696, 855-297-9696. And if you just have a question you'd like your voice to be heard, but you don't want the two-way conversation, we can do that too with our new 96.5 app. iPhones, just go to the iStore and go for the Apple Store and just go to News 96.5. Android users, WDBO, and just go up there in the search of the App Store, and it'll turn you on to the app, and then you'll have the app. It's really cool. All right, let's go on to What does shared parental responsibility means, and what if the parents can't agree on a parenting issue following a divorce?
Shared parental responsibility is the principle that major decisions affecting the children are going to be made jointly by the parents following a divorce or in a paternity case following a final judgment of paternity. Commonly, major decisions will include health, education, religious upbringing, medical decisions, and things like that. No matter how much people don't like each other and don't get along, the reality is, I think most attorneys will tell you, unless there's a strong, compelling reason not to do it, most judges are going to award shared parental responsibility, which means with respect to major decisions that are not addressed at the initial final judgment, the parents are going to have to try to work cooperatively to figure it out. If they can't figure it out at some point, one or both of them can apply to the court by motion and say, judge, motion to determine child schooling, motion to determine whether the kids should get vaccinated. And then you go into court and you each present why your position's in the best interest of the kids, and the judge will figure it out. But at the outset, on the initial granting of the divorce, most of the time it's going to be shared parental responsibility.
All right, very good. If you've got questions about family law or criminal law, feel free to give us a call right now. We are taking your calls at 855-297-9696, 855-297-9696, or text us. Just put 21232 up there where the recipient address line is, and you will be on our scoreboard right up there on the big 42-inch TV. We'll be back right here on Law 2020 after three big things you need to know.
The ho-ho of the
Hey, we're 7 minutes away from news, traffic, and weather right here on News 96.5. The show is live today. I know it's Memorial Day, but by golly, we're going to be live here, and we're going to take you right on through the show, so that means you can call or you can text. If you want to call the show, it's 855-297-9696. Text us at 21232, 21232. Now, how about getting a hold of the BCN Law Firm every day? That's easy. Just go 855-LAW-2020. You hear the singers do it on the commercial all day long. 855-LAW-2020. If you're over in the Clermont area, how about 352-394-2103? Our guest panelists are usually Wade Boyette, Heath Nalos, or Brian Monk. Brian specializes in family law and or criminal law, and sometimes they do brush up against each other, which that's a terrible thing to have happen. Can you assist with a disability claim for a person with anxiety who cannot keep a job?
Although I do primarily family law and criminal defense, you might be surprised to learn that some of those people have anxiety and have those kind of issues too. A lot of my clients have anxiety issues. I don't personally handle disability claims, but I work with attorneys who do. And I know from talking with those attorneys and seeing some of my other clients through this issue, a lot of times what they're going to be looking for is some kind of physical injury along with a mental health issue. Also, I think the Social Security, when they review the claim, they're going to be looking to see what length of time you've been unable to earn an income. And usually I think they're looking for about 12 months of time going by where you're unable to earn an income based on anxiety or some mental health issue. Not my primary area of law, but you can call the law firm at the number that's been given out, and we'll be glad to talk to you more about that.
Okay, 6 minutes before news, traffic, and weather. Now, would that entail also bringing in a psychologist or a psychiatrist to help testify on the patient's behalf?
That certainly helps the case, yes.
Okay. Let's see. This is 8647. Legal separation in 2011 in North Carolina. Moved to Florida in 2012. Wife followed in 2013. Tried to reconcile, but we can't. Is a North Carolina legal separation still valid even though we live in Florida? Does one of us have to reside in North Carolina to file for the final uncontested divorce?
If one of you has been in Florida for 6 months or more, you have established residency to obtain a divorce in Florida. My understanding, I don't practice North Carolina law, but I've had enough issues with North Carolina residents come up I believe they do require a 1-year legal separation period prior to filing in North Carolina. No such similar requirement exists in Florida other than that someone is a resident for 6 months in Florida. Depending upon what your separation agreement said, if it was sort of like a contractual settlement agreement or whatnot, those provisions may be enforceable in Florida if it sought to dispose your property, your assets, things like that. As far as an actual waiting time, though, if you've been down here that long, either or both of you have been here 6 months or more, you're good to go and file in Florida.
All right, Michael and Apopka, let's get you started. We may have to hold you through the break at the bottom of the hour for news, traffic, and weather, but you have a rather complicated question, so let's put you on the air with the one and only Brian Monk of the BCN Law Firm. Go ahead, Michael, you're on the air.
Hi, gentlemen. Thanks for having me.
You're welcome. Thanks for calling.
Yeah, I had a question for you. My daughter, she lives in Tennessee, but she was married for 6 months. She got married at 20 years old. They had a child, and then now she's 21 and going through a divorce, which I honestly couldn't see that coming. But anyways, now, she works full time, and she doesn't have anything on her record. She's very, no drugs, no alcohol, no crime. Yet the husband that she was married to, now has seeked an attorney and is filing for full custody. And he's also went to another city in Knoxville. She lives an hour away, but he got an attorney. And I guess he's also filing for some sort of a clause in there that basically states that her new boyfriend can't be around the child. I don't know what that's all about. But I wasn't sure because she calls me every day worried about, she's going to lose her child. And I keep reassuring her that the state doesn't want to have to take away, and give full rights to one parent. I think that's the last thing a judge would want to do, personally. But I wasn't sure if I can get your take on that.
Michael, that's a great question. And although it's a Tennessee case, obviously I can't advise on Tennessee law, but this is an issue that comes up in Florida often. So my response is going to be based on what occurs here in Florida. This is one of those issues that comes up often. And this is what I would call one of those best practices things as opposed to something I can point to in a statute. There's no statute here in Florida that says you can't date when you're about to be divorced or something like that, or separate from the father of your children. But a lot of judges, in my experience, don't think exposing the kids to new people is the best idea. So my advice to most of my clients when that comes up is it's certainly not the best practice, but there's nothing that's going to per se make that a problem. Now, as far as once it actually does get in front of a judge, like on that clause that you mentioned, it really just depends on the person. If the boyfriend is a felon or has some kind of issue that's going to be detrimental to the children, that's going to play differently than if he's a surgeon at the hospital. So that's right. Sort of my answer on that.
And he doesn't have a record. He actually, the long story, I don't want to take up too much of your time, but he's a friend of the family, and they basically grew up together since they were 12, and he's got a completely clean record. So, anyways, that was just my question. I just wanted to reassure her that she didn't have anything to worry about.
Yeah, I think judges want people to focus on what's best for the children, and in separation situations, it's usually considered better for the children that the parents are focusing on the kids rather than focusing on their romantic life.
Exactly. Okay, thank you for your time. I appreciate it.
You're welcome. Good luck.
Okay, we're down to less than a minute, so I'll give you the contact information one more time, 352-394-2103, or you could contact the law firm anytime this week for a few minutes of free consultations, and that's 855-LAW-2020, 855-LAW-2020. So you can go ahead and contact them this week. If you want to chime in on the show, we love it. 855-297-9696. You do not have to use your real name. 855-297-9696, or text us at 21232, 21232. We'll be back with Brian Monk of the BCN Law Firm right here on News 96.5. Hey, we're back. This is Law 2020, featuring the attorneys from the BCN Law Firm right here in Central Florida. Great thing about these guys is they specialize in various parts of the law. They got a great firm, and most of them have been around this area for so many years. They know a lot about what goes on in the various court jurisdictions and about some of the challenges that come up right here in Central Florida. You can contact them during the week at 352-394-2103, or you've heard their commercials, BCN Law Firm, 855-LAW-2020. I'm not a singer, but I play one on the radio. All right, we do have a text. You can text the show at 21232, or you could call us the old-fashioned way at 855-297-9696. Now, if you have an 828 area code and your number ends in 7444, we need for you to text us again with the second half of what your question is, because here's what we've got so far. And, folks, if you are texting us, keep in mind that your texting application may cut you off at so many elements, so you need to just keep texting until you write the whole thing. In other words, generate another text or another text or another text until we can put it all together. This says, I'm a North Carolina resident with 2 convictions on my criminal record, convicted of simple assault at 16, misdemeanor larceny at 17. One of the things he might be wondering is, can those be expunged or wipe off his record?
Yeah, and I can't speak as to North Carolina, but in Florida, if you're adjudicated guilty, then no, you cannot have that sealed or expunged. You have to have a withhold of adjudication, or the case has to have been dropped. So I think you're right. That's probably where he was heading with that. Okay,
and to the one caller or the texter at 7841, we get what you're saying. We understand it. So, reaction to one of the news stories. So we got it. All right, very good. It is 12:38. We're going back to our questions. All right, here's one. Under family law, when must a petition or a parent file a petition for relocation? Boy, that hurts. That's an ouch.
Yeah, we do have a lot of cases these days. I think that's one of the more common topics, is when someone wants to relocate either during a case or after a final judgment has already been entered. They may get a new job. They may, marry someone who has a job further out, another state or something like that. Like with most things, if the parents can come to an agreement on relocation, then they simply must just formalize their agreement in writing, set it in front of the judge, and get an order permitting the relocation. More commonly, though, people don't agree, and it ends up having to go to court. What technically the rule is if somebody is trying to change their principal residence 50 miles or more from their prior residence for at least 60 consecutive days, and if there's no agreement in place, then that person needs to petition the court to allow the relocation. If they just up and move without asking the court, and the other parent has a right to time sharing, then that is a basis that can frankly be used against them at some point in the future if that other parent seeks to enforce the current schedule. People sometimes seek to relocate a few towns away. Sometimes they seek to relocate across the country.
That kind of enters into a question that came up in my particular life. My second wife and I, moved to Florida, and they had joint custody. We get ready to move to Florida. We said, well, we'd like her to go with us. And he said, no, she would be staying there. It took several years to get that resolved. Finally, it was resolved after many, many dollars were spent, many trips back and forth to Missouri, that the judge looked out and said, how many years we've been doing this? So many, Your Honor. Nikki, how old are you now? She was in 13. He said, all right, I'm going to let you make the decision.
Yeah, and that's what's frustrating to a lot of people, is just sort of the lack of predictability as to what the outcome is going to be.
Mm-hmm. When is that age? Is there a certain age that a judge can determine that the child can make the determination?
I'll tell you, that is a real common question, and I think a common misconception, too. I have probably at least every month someone says to me, okay, this child is such and such an age. They get to tell the judge what they want, right? The judge will do what they want, right? And what the law says in Florida is that 10 years of age is not too young for a child to express their preferences to the judge, but there is absolutely nothing that requires a judge to be bound by what a child says. And quite frankly, in my experience, and I think this is a prevailing practice, judges really don't prefer to hear from the children. Oftentimes, if you file a motion to allow the child to testify, a lot of times what the judges will do is they'll say, well, I'm going to reserve on that decision till the end of the case. And if I think it'll make any difference at all, then maybe I'll hear from the child. And then 9 times out of 10, they turn to us and they say, well, now that the case is concluded, I don't think whatever this child says is going to make a difference, so I'm going to go ahead and make my ruling regardless. They try really hard to keep the kids out of it.
Is that where sometimes we hear now of people that are there doing an investigation of the family and kind of sitting down with all the partners and all the people involved? Because the child may very well be saying, well, I want to stay with Josh because maybe Josh is the one that gives her $100 a week to go to the mall with. And maybe mom makes her mind.
Right. And I think that's one of the reasons judges aren't wild about hearing from kids, is they recognize that kids can be manipulated that way, and that there's various reasons why kids are saying what they're saying that may not necessarily be the kid's best interest. What you're hitting upon is there's other tools out there like a guardian ad litem or a psychological evaluator that can be appointed by the court to go talk to everyone, do an investigation, and then come back and let the court know what they found. That's sort of an indirect way to get what's going on with the children in front of the judge. So those are common, but those do add an expense.
I bet they do. All right, we're taking your calls right now. How about Jim in Apopka? He's calling in at 855-297-9696. That is our toll-free way for you to call in the show. So, Jim, you're on the air. What's going on, man?
Good morning, guys. The state of Florida is so stuck on 50-50 child custody. We got a guy that's got 2 criminal convictions, and one of them is for drugs, and he's got 2 more criminal trials coming up. And we can't get the state off of this 50-50 that they got in their mind. And when he's doing drugs, he drives kind of funky, and the kids are fearful and so on. But the system doesn't seem to care. They seem so stuck on that 50-50. And I've been within the system to where I can tell you this. One of the reasons they don't mess with him is because he's an illegal. And that may not sound right to you, but I've been in the system, and I know that's the case. ICE won't touch him. DEA won't touch him. Locals won't touch him. He's never been in prison.
Does the person who's in this child custody battle have an attorney?
Yes.
Okay. You're right. Many judges are leaning more towards 50-50 time sharing. There was an effort to get that enshrined in the statute and the law back with the alimony legislation. The governor did not sign that, but many judges are aware that that is the trend in the law, that the starting presumption becomes 50-50. But the actual statute says there really is no starting presumption, and both parents should have opportunities to have contact and access to the children. This is one of those issues that really frustrates people because there really is not uniformity among the judges. This is one of those subjective things. There are still judges out there that will give dads, every other weekend, that kind of thing. And more, though, they're leaning towards the week on, week off, or some version of 50-50 time sharing. I would say, though, that if he's got a prior record, a criminal record, and if you could show that has any kind of effect on the children or his ability to parent, along with the fact that he's not in the country legally and may not even be able to be a steady presence for the child or children, many judges would find that relevant. I'm sitting here on a radio show. I can't tell you what your particular judge is going to do, but I think many judges would find that relevant.
Well, I've had attorneys refuse to take it. The case, they say everything's stacked against this criminal so much that it's a no contest, but yet he continues to do these violations, and they never bail him even when he's convicted. So it's terribly frustrating. I may end up having to talk to you during the week.
What I would start to think about is not so much the guy being a bad guy or whatever, but what connection it has to the children. I've heard all sorts of mud being slung in court, and the judge will turn around and say, well, that's compelling and that's interesting, but tell me what effect it has on the kids. So start thinking about it in those terms, trying to paint that picture moving forward. Okay, Jim, and if you need further consultation, what you'll want to do is call during the week. You can call the law firm right here at this number, 352-394-2103 or 855-LAW-2020. That is 855-LAW-2020.
2020, and you can give them a call on that at any time this week. Will the offices be closed tomorrow, Memorial Day Monday?
Yes, we're closed tomorrow, but we'll be back at it Tuesday.
All right, very good. And we are taking your calls right now on air at 855-297-9696. That's 855-297-9696, or you can text us at 21232, 21232. Here's an interesting one. Family law question. What dates are used to determine whether an asset or a debt is marital versus non-marital or separate?
Yeah, that's a common question that I receive, and this is one of those areas that does have a bright line rule in the statute, but people often get confused by it. The judge is going to look at what were the assets and debts as of the date of marriage, and the other endpoint in determining is the date of filing for divorce or the date of a valid separation agreement. So things that were acquired, assets or debts that were acquired since the date of marriage and up to the date of filing for divorce or the entry of a valid separation agreement, that's going to be the window a judge is going to look at to identify marital versus non-marital assets and debts.
So does that kind of eliminate the age-old practice back in the 60s, 70s, and early 80s of somebody, they separate, they file for divorce, and then one of the two parties goes out and runs up the credit cards to the nth degree?
Well, when you have the bright line rules there, that certainly someone doing that after the date of filing, the presumption is going to be that that's going to be their debt. Now, there is another mechanism in the law that if somebody does run up a debt prior to filing, then the other party can ask for an unequal distribution of assets and debts. They can say, Judge, I know the starting presumption is an equal split, but here's a reason why it should be unequal.
All right, we're going to come back with Leonard's call, and we have a second call being lined up right now, and maybe you have a text question at 21232, 21232. Give us a buzz. We'll appreciate it, 855-297-9696, and when we come back, I'm going to give you contact information for the BCN Law Firm. You're listening to Ask the Experts all weekend long on News 96.5. Hey, welcome back to the show. We have 6 minutes to spend together. Let's use it wisely on the Law 2020 program featuring Wade Boyette, Heath Nalos, or Brian Monk, all from the BCN Law Firm. You want to contact them during the week? Just dial 855-LAW-2020, 855-LAW-2020, or bcnlawfirm.com, bcnlawfirm.com. You can call the show right now at 855-297-9696, 855-297-9696. And we go to Tammy on the line. Tammy, how can we help you?
Hello?
Hi, you're on the air.
Hi. My name is Tammy, and I'm calling. I had a friend that fell ill. She has kind of set it up. She lived with her boyfriend and the child of 9 years and lived in a home that she owned, and she passed away after a protracted illness. And so it's the father and the child, but she had a will drawn up, but during the protracted illness, the family kind of coerced her and changed the will to having the grandmother, her mother, being the executor of what bits of money she had and pieces of property. After the death, basically the grandmother, the mother, is trying to take over and evict the father from the property. And then they're probably, they've made intimations that they might go after the minor child as well, who's 9 years old. I guess my question is, what rights does the father, they're making it look like he's a squatter on that property and he's lived there for 10 years. I mean, I've known them for 10 years and they've lived together for 10 years, but they weren't married. So I guess one is it's Florida law as far as living in that property and who does it go to? Does it go to the minor child's estate? Does the father indeed have to move? And then secondly, should something happen to the father if he were hit by a bus? I understand there's some things in Florida law that everybody has equal access to claim rights to the minor child no matter what is said. So I kind of have two questions in there.
Okay. Thank you for your question, and I'm sorry to hear about your friend. I'm sure that was an unexpected situation that everybody's in. From what you've told me, I think ultimately, if the will is valid, the will is going to direct the disposition of her property, and ultimately, he's going to the father of the child is going to have to leave, and that home is going to be disposed of by probate through the will. Anytime someone's in a home, though, you can't just kick them out overnight or with a letter. There's a process, a legal process that's going to have to occur. So ultimately, if her property was disposed of by a valid will, it's ultimately going to go into her estate. Now, whatever that will says about her child's inheritance portion and this and that, possibly an attorney might be able to help the child, and the father to have claim to that home, to try to preserve the home if it can be argued that the home or enough of the estate was willed to the child. So that would just depend on what that says. With respect to custody of the child, unless there's some serious DCF type issues involving the biological father, nobody else is going to have a superior right to this child than the biological father.
That was my question. Now, should he pass, and even if he makes his wishes known, there was some folks that have said, and some lawyer folks that have said that then it's kind of, even though he's made his wishes known in a valid will, the grandmother and other folks can still stake claim to that child and go for custody of that child.
I would agree with all that, and there would be a hearing, and the judge would consider what's best for the child. And if the biological father makes his wishes known, especially with some clarity and specificity, those are some instructions for a court to consider down the road. Not binding, but helpful.
Right. Okay. And so as far as we've had difficulty with folks wanting to look at the case because there's so many arms. There's a probate arm and there's a custody arm possibly. That hasn't occurred yet, but there is a probate arm that's occurring. So, I mean, is there somebody out there that handles both of those, as far as, do you guys handle both types of
Yeah,
law?
that's the great thing about being involved in a firm that handles so many different areas of law. I would be involved in the family law portion of it, and Wade Boyette would be involved in the probate portion of it, and we'd work together as a team to accomplish all your legal needs. So yes, we could help you out.
Great. Well, I mean, I appreciate it. I really appreciate the time.
Thank you. Wish you the best.
All right. Have a great day.
You too.
All right, here we go. Let's see. Let's ask, number 5 under family law. What date will a judge use to value assets and liabilities before distributing marital property in a divorce case?
Well, that's a question that commonly goes along with the other question that we talked about, the dates for identifying whether it's marital or non-marital. We said earlier that's going to be from the date of marriage to the date of filing is the window for that. When it comes to actually valuing the assets, that's where it gets to be a little bit more of a free-for-all. The parties can argue and litigate that issue because it's ultimately up to the judge as far as what dates are going to be used to value different assets. And another interesting point is different assets can be valued as of different dates. The judge can decide to value the home as of the date of filing and can decide to value the car as of the date of the final hearing or anywhere in between. So that's another issue that's commonly contested.
Okay, real quick. I don't have a 401k fund, but my live-in partner does. I've been with her for 17 years. Do I have any rights to half of her 401k?
Just for living with someone and without any kind of contract or agreement in place? No.
All right, very good. The BCN Law Firm, 855-LAW-2020, 855-LAW-2020, or you could always go to bcnlawfirm.com. We keep asking the experts all day long right here on News 96.5.